Good afternoon, everyone. Today, the Justice Department filed a lawsuit against the state of Idaho. The suit seeks to hold invalid the state's criminal prohibition on providing abortions as applied to women who are suffering medical emergencies. Under a federal law known as the Emergency Medical Treatment and Labor Act, or EMTALA, every hospital that receives Medicare funds must provide necessary stabilizing treatment to a patient who arrives at an emergency room suffering from a medical condition that could place their life or health in serious jeopardy. In some circumstances, the medical treatment necessary to stabilize the patient's condition is abortion. This may be the case, for example, when a woman is undergoing a miscarriage that threatens septic infection or hemorrhage, or is suffering from severe preeclampsia. When a hospital determines that an abortion is the medical treatment necessary to stabilize a patient's emergency medical condition, it is required by federal law to provide that treatment. As detailed in our complaint, Idaho's law would make it a criminal offense for doctors to provide the emergency medical treatment that federal law requires. Although the Idaho law provides an exception to prevent the death of a pregnant woman, it includes no exception for cases in which the abortion is necessary to prevent serious jeopardy to the woman's health. Moreover, it would subject doctors to arrest and criminal prosecution even if they performed an abortion to save a woman's life, and it would then place the burden on the doctors to prove that they are not criminally liable. The United States therefore seeks a declaratory judgment that Idaho's law violates the Supremacy Clause of the United States Constitution and is preempted by federal law to the extent it is in conflict with EMTALA. The United States also seeks an injunction prohibiting Idaho from enforcing its law against healthcare providers who provide the emergency treatment required by EMTALA. In the days since the Dobbs decision, there have been widespread reports of delays and denials of treatment to pregnant women experiencing medical emergencies. Today, the Justice Department's message is clear. It does not matter what state a hospital subject to EMTALA operates in. If a patient comes into the emergency room with a medical emergency jeopardizing the patient's life or health, the hospital must provide the treatment necessary to stabilize that patient. This includes abortion when that is the necessary treatment. Any state law that prevents a hospital from fulfilling its obligation under EMTALA violates federal law. On the day Roe and Casey were overturned, we promised that the Justice Department would work tirelessly protect and advance reproductive freedom. That is what we are doing, and that is what we will continue to do. We will use every tool at our disposal to ensure that pregnant women get the emergency medical treatment to which they are entitled under federal law. And we will closely scrutinize state abortion laws to ensure that they comply with federal law. I would now like to welcome Associate Attorney General Vanita Gupta, who is the head of our Reproductive Rights Task Force, to the podium to share more details from our complaint.
Thank you, Attorney General Garland. The complaint alleges that Idaho's law is contrary to EMTALA because it presumptively criminalizes all abortions, making it a felony for doctors to provide emergency treatment required by federal law, even where a denial of care will likely result in the death of the pregnant patient. The Idaho law flatly prohibits abortion even where medically necessary to protect the health of the patient, such as where women are experiencing incomplete miscarriage or severe preeclampsia. Specifically, Idaho's law, which takes effect on August 25th, places the burden on physicians to prove at trial, following arrest and indictment, that they are not criminally liable. Physicians can only do so by proving that the abortion they performed was necessary for one of two reasons: to prevent the death of a pregnant woman, or in response to a case of rape or incest that was previously reported to the police, or in the case of a minor, to Child Protective Services. Physicians who do not meet this burden face 2 to 5 years imprisonment and revocation of their medical license. And the law provides no defense whatsoever for when the health of the pregnant patient is at issue. Moreover, under the Idaho law, healthcare professionals such as nurses and lab techs face license suspension and potentially revocation for even assisting with abortions. The law thus places medical professionals in an impossible situation. They must either withhold stabilizing treatment required by EMTALA or risk felony prosecution and license revocation. In so doing, the law will chill providers' willingness to perform abortions in emergency situations and will hurt patients by blocking access to medically necessary health care. The United States, therefore, seeks a declaratory judgment that Idaho's law violates the Supremacy Clause of the United States Constitution and is preempted by federal law where it conflicts with EMTALA. The United States also seeks declaratory judgment that Idaho may not punish medical providers based on their performing an abortion authorized by federal law. And we seek an injunction prohibiting Idaho's enforcement of this law to the extent it conflicts and prevents physicians from providing the emergency treatment that federal law requires. In the wake of Dobbs, the Justice Department established the Reproductive Rights Task Force and to formalize our ongoing work to protect reproductive freedom. One critical focus of the task force has been assessing the fast-changing landscape of state laws and evaluating potential responses to infringements on federal protections. Today's lawsuit against the state of Idaho for its near absolute abortion ban is the first public example of this work in action. The task force's other work includes advising agencies on legal issues that have arisen post-Dobbs, coordinating technical assistance both to Congress and to states on federal constitutional questions, and meeting with members of a broad array of stakeholder groups, including states' attorneys general's offices, members of litigating, reproductive justice and provider groups, and members of the pro bono legal community on our collective efforts to protect reproductive care. We know that these are frightening and uncertain times for pregnant women and their providers. And the Justice Department, through the work of its task force, is committed to doing everything we can to ensure continued lawful access to reproductive services. And now I'd like to turn the podium back to the Attorney General, who will take some questions.
Well, apparently I'm going to take some questions.
Sarah Lynn with Reuters, thanks for
Hi,
doing
Sarah.
this.
Of course.
Can you talk a little bit about why you decided to select Idaho as your first legal challenge since the Dobbs decision? And also, there's also been reports about some people in certain states like Texas having trouble accessing medications they need, not just for abortion, but also if they're undergoing a miscarriage and they need that medication. And there's been reports I've been hearing about people who are unable to access that. So are you going to be doing more to ensure that people have access to the medications that they need for reproductive health care?
So on the first question, we have in front of us a statute that seems to us on its face to directly conflict with EMTALA that is about to take effect and that will threaten the health of women who come to the emergency room in a really dire medical situation. When we find that statute appropriate for us to vindicate the rules that Congress established in EMTALA, that's why we're bringing this case. On the second question, we are receiving many reports like the ones you're talking about. The Reproductive Rights Task Force that the Associate Attorney just spoke of is evaluating them and making determinations about what further litigation we'll seek.
Hey, thank you very much. Rob Lear, CBS. Just wondering if you had any further insight into this weekend's drone strike against Ayman al-Zawahiri and any part that you or the Justice Department played in that decision, and any further comment on it.
So I think the President has said pretty much all that I would be at liberty to say. I think the general point that the United States does not forget people who kill American citizens and will find them and punish them no matter how long it takes was the point of the President's statement and is the point of the Justice Department's statement.
Guess we're doing separate topic questions. I'd like to ask you about this call for lawmakers that the Justice Department now get involved in this increasingly kind of concerning news about the missing texts that have been found from the Secret Service around January 6th. Do you expect the Justice Department to get involved, and do you have confidence in the current DHS Inspector General who is investigating this?
All right, so as a general matter, any allegations of wrongdoing about inspector generals are handled by what we call SIGI, which is the Council of Inspectors General on Integrity and Efficiency. That's the way those kind of allegations are handled. And without commenting on this particular case, needless to say, the Justice Department's job is to investigate allegations of violations of the criminal law, including allegations regarding matters involving the scope of inspector generals.
Are you concerned about the missing text, though? I mean, is that something that's not?
I don't want to talk about particular cases. With respect to our own investigations, we pursue all facts as far as we need to pursue them, and we'll pursue them with all the tools we have under the criminal law.
On this issue announced today, if I could just ask you real quick, you have enormous respect for the Supreme Court. What's the point of the Supreme Court if DOJ is going to go around and do these kinds of things? Will there be other states like this, you think?
I'm not sure what you mean by what's the point of the Supreme
Well, I mean,
Court.
what,
I could give you a long discussion on the point of the Supreme Court.
But if DOJ is going to go around the Supreme Court
This is not in any way going around the Supreme Court. The Supreme Court said that each state can make its own decisions with respect to abortion, but so too can the federal government. Nothing that the Supreme Court said that the statutes passed by Congress, such as EMTALA, are in any way invalid. It's quite the opposite. The Supreme Court left it to the people's representatives. EMTALA was a decision made by the Congress of the United States. The Supremacy Clause is a decision made in the Constitution of the United States. Federal law invalidates state laws that are in direct contradiction. This has really nothing to do with anything that the Supreme Court said, and certainly nothing to do with going around the Supreme Court.
Thank you all.
Thank you.
Okay.